Hello and welcome to Absolute Trust Talk. I am Kirsten Howe. Normally I say I'm Kirsten Howe, the host, but today it's going to be me and Madison Gunn, our associate attorney. If you've been paying attention to our podcast, you know that from time to time Madison comes on and we just kind of had a conversation together. So I don't feel like I'm the host and she's the guest. We're just doing what we normally do almost every day, talking about our cases. And today we're going to be talking about this particular variety of case that we've been getting in the office quite a bit. I think, Madison, would you say we've had a spate?
Yeah, I would. Yeah.
A spate. So, and they are related to our special needs planning work, but we want to talk about these cases because they are the problems that we are seeing that people are having are things that everybody needs to know about. They're not just unique to somebody who happens to have a disabled child and needs to do special needs planning. It can impact everybody who does an estate plan, which should be everybody. So we're going to talk about this, and hopefully everybody will take something away from it. Without, belaboring it, Madison, good to see you. And how are you doing?
Good. Thank you. I know. It's been a couple days since I've seen your face.
Yeah. Okay. So let's just get right into it. Talk about, what's going on? What are these cases that we've been seeing? What's the common denominator?
Yeah. So the last few weeks, we've had quite a few of people calling saying that their child, mother, sibling, whomever is going to inherit money via a probate or a trust administration or something. And that person that's inheriting is on needs-based government benefits.
Okay. And just to remind our listeners for whom this is not front and center all the time, when we're talking about government benefits, there are so many different government benefits. Some of them are what we would call status related benefits. So for example, Medicare, that's a government benefit. All you need to qualify for Medicare is to be 65. When you turn 65, you qualify and you get it. And you don't have to prove that you financially need that benefit. You just get it. But we are talking about government benefits that you have to be financially in need of, right?
Yes, yeah. And then receiving that inheritance that's coming to them directly makes them typically lose those needs-based government benefits. There's usually a cap on the amount of cash they're allowed to have.
Right. They can have a certain amount of income, they can have a certain amount of assets, but once they get past those caps or thresholds, they can lose the benefit. And typically what we're talking about is either SSI or Medi-Cal or both.
Yeah.
Okay. And so we do, we do special needs planning for our clients. We want to set up a special needs trust so that inheritances can be received without causing ineligibility. But that's not what happened in these cases. What went wrong in these cases? We were not their attorney. We did not do a special needs trust for them. What exactly went wrong?
Yeah, so we had a few different ones. One being that, a sibling passed away and they didn't have any estate plan at all. And so all of their assets, retirement account included, went via intestacy, which means if you don't have a plan, the probate code steps in and says who gets to inherit from you, depending on who's alive when you die. And this sibling received a third of the deceased sibling's estate, and that sibling that received it has been on public benefits since he was 18. And so there was no plan, and, that required a whole lot of effort to get that money for him without him losing all of his benefits. And I mean, it's not just Medi-Cal, people who are on SSI or even other forms that aren't SSI, those regional center benefits, they find you housing at super low income housing and all of that you don't want to lose because of that. We've also had people who just didn't update their trust. So, grandparents leaving money to grandchildren, and, they do it before those grandchildren are even born. So if they didn't update their trust, then all of a sudden you might have a special needs grandchild inheriting money that they shouldn't inherit or shouldn't inherit directly because they'll lose their benefits. And then we've had ones where people set it up for them to be in trust. A lot of people like to leave things in trust for their children until they're a certain age, but that's a different type of trust. It's not a special needs trust. It's considered a general needs trust. And that would also disqualify them.
Right. And the not to get too technical, but a general needs trust allows the trustee to make distributions for kind of almost anything, general needs, whereas a special needs trust, very restricted, the trustee can only make certain kinds of distributions that won't disqualify the beneficiary from their government benefits. So a trust isn't the whole answer. It has to be special needs trust. Okay. So because of the way these inheritances played out, it is going to be considered an available resource, and therefore these people will lose their benefits.
Yeah.
And there's a way to save that. I mean, that's why we're here today. We're going to talk about what can you do to fix that problem also, but more importantly, what can you do to avoid that problem? Sometimes, though, the fix, it seems like it's almost not even worth it. If the inheritance is very small, you got to spend a bunch of money to fix the problem, which brings me to the estate plan. One of the estate planner's taglines, it's always cheaper to plan ahead than to fix a problem afterwards.
Yeah, we can always rescue it and we can always fix it, usually, but it doesn't always seem worth it.
Yeah. It in some ways it doesn't seem worth it, but when you think about losing a benefit for months or years, right, that is worth it. Even if it costs money to clean up the problem, it's worth it to not lose your Medi-Cal for 2 years. Okay, so what are the fixes available to us in these situations?
Sure. So if the inheritance is outright, if it's whether it's through a probate, intestacy, or a outright trust distribution, or a beneficiary designation on a bank account or brokerage account, then the fix would be to do a special needs trust. But instead of having your family member set up that trust for you in advance, it would be considered a first party special needs trust. So that can be done. And there's a few different ways that can be done. And then, of course, if somebody has that a trust where it's going to be in a general needs trust for them, we can petition the court to modify the trust to allow them to convert that to a special needs trust.
Okay, so let's focus on that first point, which is we've got the inheritance is coming either through intestacy or some outright distribution. And you said first party special needs trust.
Yeah.
And that's an important point. It's considered a first party special needs trust because we are taking, I'll call them the special needs person. We are taking their money and putting it into a trust.
Right.
Because
that essentially they create.
Yes. And it's considered their money because they inherited it outright, even though yesterday it wasn't their money. When grandma was alive, it wasn't their money. It was grandma's money. But now that grandma has passed away, it's your money. So we have to create what's called a first party special needs trust. So what are the important points to know about a first party special needs trust?
Yeah, on a basic level, the two requirements for a first party special needs trust is that in order to create one, the person receiving the money has to be under 65, and there has to be a provision to pay back Medi-Cal in the trust. So when you're writing the trust, it has to say that, after the beneficiary dies, then the money goes to pay back whatever Medi-Cal bills they might have.
Right.
Yeah.
Right. So whenever someone who has received Medi-Cal during their lifetime dies, we notify the Department of Healthcare Services, and they will send a bill saying, this is how much we spent on this person, and you got to pay it back. If you have a first party special needs trust, you have to pay it back out of that trust. Some of the planning we do is to help our clients avoid having to pay that money back, and that's fine. That's a perfectly legitimate thing to do, and most people would prefer to do that. But with the first party special needs trust, you can't avoid that. But at least you get to keep the money in the trust while you're alive. It's there to be spent. You're not losing that inheritance. Now, but Madison, you mentioned two things. It's got to pay back Medi-Cal, and you also have to be under 65. What happens if the beneficiary is not under 65?
Yeah. So if they are 65 or older, they cannot set up a first party special needs trust for themselves. The resource available to them is called a pooled trust or a pooled special needs trust. And typically those are run by a third party, usually a nonprofit, that gathers everybody that is involved, their inheritance or whatever they're getting, and put it into a pooled trust that is still used for their benefit. But when they pass away, the money goes back into the pot, and the income from the pooled trust usually benefits a nonprofit.
Right. So that's just important to know, and sometimes that's what we have to do. We don't have any other real option, but at least the inheritance is there. It can be used, and we don't lose benefits. Okay, so what about the idea, clients will always ask, well, can't we just take the inheritance and give it away, and by doing so not lose our benefits? Can we do that?
No. So in order to give it away, it has to be yours. And if it's yours, it's counted against you. So, in the most simple form. And if you don't want it, you can say that you don't want it, but it's still going to count against you, at least for that moment that you have it.
Right. So just saying, just giving it away, you have to report it. You have to report it. I got this inheritance and I gave it away, and it doesn't really solve the problem. Okay. So you might lose your Medi-Cal for a period of time, or you might end up with a share of costs for a period of time. And some people I'm sure out there, we have very smart listeners taking this to the next step. Well, why don't they just say, don't give me the inheritance?
That's kind of for the same reason. It's considered, they call that a disclaimer. You sign off saying you don't want it, and you still have to report that. It's still a reportable, even though it doesn't actually touch you, as opposed to someone writing you a check and you endorse it to somebody else. That's a gift. Even though it doesn't actually go to you, disclaiming it still means you have to report that.
Right.
And so there would still be that possible penalty from the benefit.
Right. So from the standpoint of Medi-Cal and SSI, a disclaimer is no different than actually getting the inheritance and giving it away. It's the same thing. You have to report it, and you might get penalized depending on the type of Medi-Cal that you have. And SSI, you will get penalized for giving away assets. Okay. Now we're going to go to our Ask Kirsten segment, our ever popular Ask Kirsten segment. Now, these questions in the Ask Kirsten segment aren't necessarily related to the conversation we're having today, because these are questions that we get by email from whoever. Someone said, why don't you answer this on your show? If you have an Ask Kirsten question, please feel free to email it to us. You can go to our website and email it that way, or you can email it to info at absolutetrustcouncil.com. We love to get questions from our audience, and I'm happy to answer them. And we like this segment, so please don't hesitate. Okay, so my Ask Kirsten question for today. My mother died in 2018. She had a trust, and we 3 siblings are the beneficiaries. My brother is the trustee. But we still have not received our inheritance, and it's been 3.5 years. What can we do? Okay, so I call this Ask Kirsten, but I have Madison here, so we're going to have her chime in too. I'm going to turn it over to you. Yeah, go ahead.
That's an unfortunate answer to that question, because what you can do is you can hire an attorney and petition the court to force the trustee to do their job. Right. I don't know, obviously we don't know what the trust says, but most likely they're supposed to have been presenting an accounting every year to the beneficiaries. And, you know, the ubiquitous answer is it's all whether it's reasonable or not. So it just depends on the circumstances.
Right, right. And that your point is well taken, that we, you know, that question doesn't give us all the facts we really need, but the bottom line is the beneficiaries do have a remedy, and the remedy is you can always go to a judge and say, hey, this trustee is not doing their job. We need your help, Your Honor. And that is available to you. We at Absolute Trust Council don't do litigation, but we do have colleagues who take those kinds of cases on for our clients, if that ever comes up. Okay. Thank you for that question. And now we're back to the episode again. So Madison, we've been talking about, most specifically, we were talking about when the inheritance comes to the special needs person outright. But as you mentioned earlier, some of our clients get their inheritance in a trust. In other words, it's, let's say, in my scenario that I mentioned earlier, grandmother died, and now the trustee is going to hold the inheritance for these grandchildren for some period of time. You know, commonly it'll say until the person turns 25 or 30 or some other kind of milestone. So what's going on there? What can we do for those people?
Yeah. So the point of those trusts, the general needs trust, is saying, you know, it's, you hold it in trust for Timmy till he's 25 or 30. The point of that is just essentially you don't want to hand an 18-year-old, you know, a couple $100,000. Right. So it's not that restrictive in the sense that the trustee can use it spend it on that child for nearly anything. What that doesn't work for is needs-based benefits, because they require much more restrictive language. Now, the funny thing is it just says at the trustee's absolute discretion, which you would think is actually less restrictive, but the trustee's job is to be restrictive for the purpose of maintaining those benefits. So if there is a trust that a special needs person inherits from that's set up like that, essentially it doesn't address the fact that they are special needs, then we can petition the court to modify the trust so that the terms of that general needs trust for that child or special needs person are changed to be a special needs trust as opposed to a general needs trust. So it makes it more restrictive and allows the trust to continue on. Yeah,
and what we're typically saying when we petition to modify is that circumstances have changed since that trust was written, and now the trust really doesn't work well, because when the trust was written, we didn't perhaps know that this person was a special needs person, or maybe the person wasn't born, so we didn't know, or the person had some kind of sudden disability, and there just wasn't an opportunity for the trust to be revised, and then somebody died. So we're typically saying we need to modify this trust because circumstances have changed and it just is not appropriate anymore. But okay, so we talk about this, you know, oh, a petition for modification. What we know what that means because we do it all the time, but what exactly does that mean for those out there in the audience listening to this?
So it's time and money. That's always what it means when we have to go to court. I mean, our practice isn't typically played out in court unless we have a probate, and we try to avoid those too, just because they take a long time. I mean, certain counties are scheduling for next summer for a hearing. So if you're looking to, petition the court to modify the trust and maintain that money, you're not going to have access to it until that happens, because you don't want it to become available and lose public benefits. So, even though the special needs person is getting benefits, you might need that money to supplement something for them. And so you want to be able to get access to it. So it requires, work. The petition, everybody has to get noticed. Everybody has a chance to object. Those are all little things that could throw red flags, especially if there's some errant family member that just likes to cause trouble. That happens sometimes.
No.
You wouldn't think so in this case, but
never.
So, it just is a lot of time usually in order to get that trust modified.
Yeah, and money, and that would not have to have been spent if the modification, which we would have called an amendment. Prior to death, we call it an amendment. After death, we have to call a modification. If it had happened before death, it would have been much easier, much cheaper.
Yeah, crisis calls are always much more expensive than planning ahead.
Right. That's a really good tagline. Crisis is expensive. Plan ahead. Okay. So let's look at our audience questions while hopefully I can do this. Kirsten's having to handle a lot of technology. I was saying before we went on, it's a lot. Okay, but I can do it. Audience questions. Oh, okay. Here's one. What if the person inheriting property is receiving SSDI? Okay, we didn't mention SSDI.
Okay. Yeah. So SSDI is Social Security Disability Insurance, and that is something that you have to pay into in order to obtain it if you become disabled. So you have to have your 10 years or 40 quarters of work over your lifetime in order to receive it. Because you paid into it, it's not a needs-based benefit. Whereas SSI is typically because you've become disabled prior to any work history. So people who are born with a disability, they can't possibly pay into SSDI. So there's a basic minimum amount the government's willing to give you for the rest of your life to cover that. So SSDI is not a needs-based benefit. It doesn't come with Medi-Cal automatically like SSI does. So unless you're receiving some other needs-based benefit, an inheritance will not affect your SSDI.
Yeah. Okay. Okay. Can you do a petition to modify a trust into a special needs trust if there's more than one beneficiary and not all the beneficiaries are special needs persons?
Yes, we can customize any petition to be the specific needs for that special needs person.
Okay. Short answer, and short answers are good. Yes, we can do that.
Yeah.
Okay. I have one more here. Can you just add the inheritance to a special needs trust that the parents set up for when they die? So, the parents did the planning. I'm guessing parents did the planning. There is a special needs trust. And now the grandparents have died and there's an inheritance coming.
So the short answer is no. And the preventative answer is if you set up a special needs trust for your child, a third party special needs trust, meaning someone else is doing it, shout it from the rooftops. Tell everybody to update their estate plan. If you're leaving any penny to them, make sure it's left to their special needs trust instead. Right. But you can't divert it because the trust and the beneficiary are two different people. Right. And so you can't just say, oh, this money for Kirsten should actually go to this other entity. Right. It's not the same. They're not treated as the same.
Right. And so that brings us very nicely, thank you, Madison, to the, what will we call it, the moral of the story. The moral of the story, two things, I think. If you are doing estate planning anybody who's doing estate planning, you need to have this, what I call just in case provision in your trust or your will. If you don't have a trust, you have a will. You need to have this because you never know. 20 years from now, you're going to have a grandchild who is a special needs person, and you never thought about it. And why would you? You need this just in case. Just in case one of my beneficiaries turns out to be a special needs person, we're going to treat this like a special needs trust.
Right. It already has all the terms you need. You don't have to petition to modify.
Right. In my opinion, every trust should have that. If you don't have a trust, your will should have that. Okay, so that's number one. And number two is what Madison said. If you are the parent of a special needs child, you got to set up a special needs trust for them and tell all your family members. We already set this up. It's very easy. I'm not asking you for any money, but if you were thinking you're going to leave something to my child, this is where you need to leave it. And just make sure the family knows about it.
Yeah. I mean, even to the point of, an IRA beneficiary, anything that you can think of. It's not just your will or your trust, but any other asset that you might have listed beneficiaries on, your annuities, your life insurance,
Yeah, that's a really good point, because sometimes that's where that kind of money comes from, is those IRAs. Yeah. Okay. So hopefully you all got that, and you got those 2 points, and you'll do it. You'll take care of that. I hope you got a lot out of this episode. Thank you, Madison, for helping me. And thank you for watching, for listening, for being in our audience. If you like this show, like it, subscribe to it, do all those things that you're supposed to do. And thank you. I look forward to connecting with you next time.
Thank you for joining us today for another episode of Absolute Trust Talk Live. If you enjoyed listening in, then don't forget to subscribe. You can find us on Apple Podcasts or wherever you may listen by searching Absolute Trust Talk. While you're there, we would also love for you to leave us a review. And then why not share your favorite episodes with family, friends, or colleagues too? You can find all of our shows and corresponding show notes by visiting absolutetrustcouncil.com. You'll also find a variety of other free resources, including our ebooks, videos, blogs, presentations, and more. If you need help with your estate planning or administration, we also offer a free discovery call to help get the process started. You can find more information on booking your session by visiting absolutetrustcouncil.com/scheduling. Don't forget to keep an eye out for our next live episode in 2 weeks. If you join us for the broadcast, you can submit questions during the show. But if not, don't worry. You can always get in touch with us by sending a quick message to info@absolutetrustcouncil.com. Thanks again for listening. We'll see you soon.